So this is me. We might move on to the next slide. I have to ask Molly to change it over because there was some problem. And as you see, I got the President's Medal and had my subtle smile there. We go on to the next one. This is Ezra is on the call today. She'll remember this moment. This was the International Surrogacy Forum. The International Surrogacy Forum was an idea of myself originally and the late Anne-Marie Hutchinson. It was originally held in Cambridge in 2019. This was the second iteration about 4 weeks ago in Copenhagen. And on day one, this is not how I dressed. This is how I dressed on day two. On day one, I dressed in a suit, much like everyone else here, except I was in black. A black shirt, black suit, and did my presentation. All day, I had heard on the Thursday, which was a very warm day, and the building in Copenhagen did not allow for air conditioning, so we all steamed or stewed in various ways, about how there needed to be a genetic relationship between parent and child to do surrogacy. I was absolutely outraged by that, because what it meant was that if you had a gay couple, for example, then one of the dads wouldn't be recognised as the parent. The surrogate was going to be the other parent. If you had a single woman, and to give an example, 37-year-old theatre nurse who'd undertaken, who'd had cancer and needed an egg donor, sperm donor, and surrogate, she wouldn't be included at all. So on day two, I thought I'd dress in cooler clothing. And this particular shirt is one that I wore at Sydney Mardi Gras, again, Lesbian Mardi Gras, early this year when World Pride was on, when my husband and I marched. And I thought, I'm going to wear this shirt because everyone needs to see how I think about it. What I didn't expect, I hadn't thought of, but is obvious in retrospect, in wearing this shirt, the loudest shirt that anyone could wear there, I photobombed every photo I was in. So we might go on to the next slide. And this is my first surrogacy case. I was practicing, this is how I got into surrogacy of all things. It wasn't through my own issues to do with fertility, although that certainly assisted. It came about, it's a simple, someone walked through the door, a woman walked through the door, and she was a traditional surrogate. I hadn't got through an IVF clinic. And she asked the question, can I keep the money in the baby? And it was a baby boy. She'd been paid $10,000 by the married couple to have the child. And of course, they hadn't had any counselling and they hadn't had any legal advice, because way back then, no one did any of that. And we'll go to the next slide. And I remember what I thought by her saying this, that she wanted to keep the child. And I felt very sorry for the couple. And I was appalled at the attitude of this woman who'd come in to see me. But the Surrogate Parenthood Act had commenced in Queensland. So it was the only law nationwide that made it illegal, wherever you were, if you were from Queensland, in engaging in surrogacy. So whether it's traditional, gestational, or commercial or not, didn't matter. It was a criminal offence, whether it was in Queensland or anywhere else, it didn't matter. If you're ordinarily resident in Queensland, you'd commit the offence. So Queensland, unfortunately, is the birthplace of this view of extraterritorial laws concerning surrogacy. And it's been copied since Queensland, and the ACT was next, then Hong Kong, then New South Wales, and currently Italy is looking at having extraterritorial laws. And as a reaction to the Baby M case, where the surrogate had been paid $10,000 US to have a child, and she decided, it was traditional surrogacy, she decided that she wanted to keep the child. It ended up in the New Jersey Supreme Court, which held that the agreement was void, but in the best interest of the child should be with the intended parents, because the intended father was the genetic father. So my advice to my client was the agreement was void, therefore the money lay where it fell. She had the money, so she'd keep it. And chances were, if the matter were litigated, then she would be successful, as she was seen to be the mother. And as you see in the note, that's what later happened in Re Evelyn, which was 10 years later. And indeed, there was another case before the same judge at the same time as Re Evelyn. I wasn't in that, but there were two at the same time. And most likely, my view was it would never be litigated because there was the risk that the intended parents, by bringing an application to the court, would be prosecuted. And it never was litigated. What always has concerned me about that case is whether the baby boy in that case, assuming he's still alive, has ever been told the truth of how he was created. And I think one of the things that Victoria in particular can hold its head high is this commitment to children that they can find out where they've come from. And in this case, I doubt whether this boy has ever been told about where he came from. Okay, we'll go to the next slide. And then we move forward a few years, and by this stage I was doing some surrogacy work, but not much, because basically my clients would come in and I'd tell them it was illegal. Where I was lucky, funnily enough, out of adversity, was after the first minute when I told them it was illegal, they would then ask me, well, where is it legal? So I had to look it up nationwide where surrogacy could be done. Then, following the travails of Senator Stephen Conroy and his wife Paula Benson, who are from Victoria and had to go to Geneva in New South Wales trying to take surrogacy there because Victoria in effect prevented them from doing so, there was a movement nationwide to have laws that allowed altruistic surrogacy but criminalised commercial surrogacy. And in Queensland, that is the Surrogacy Act, so it took over from the Surrogate Parenthood Act. When the surrogacy bill came before Parliament, it had identical provisions. And when I say identical provisions, there was a government version, and oddly enough, there was an opposition version. And how the opposition version came about was absolutely shameful. There was an LGBT event at Queensland Parliament House. I went to it, and it was an all-party event. And afterwards, there was a barbecue. And the then Shadow Attorney General from the LNP went to the first event, then disappeared, and then turned up at the barbecue. Where he was at in the intervening period was actually with the Parliamentary Council, drafting his version of the surrogacy bill, and its difference between the opposition and government version was, as seen, the LNP version excluded recognition of the non-biological mothers in lesbian relationships as parents, and criminalised gays, lesbians and singles undertaking surrogacy with up to 3 years jail. Luckily, the LNP version was not enacted. There was a conscience vote both sides. But by 2012, the Bligh government was thrown out, the Newman government was elected, and Jared Bligh, the then attorney, stood up in the House and said to the effect, well, we're going to now enact the earlier version of the LNP bill. And this was with the vociferous support of the Australian Christian lobby. 7 of us got together and we gave ourselves the noble title, Queenslanders for Equality. One of us wasn't even a Queenslander, that was Alex Greenwich, who's got his current equality bill through the New South Wales Parliament. And ironically enough, given the time frame, it took us 9 months to be successful. I thought our chance of success was somewhere between 0 and 3%, but it was so offensive that someone should be criminalised based on their sexuality. And to have Queensland out of kilter with the rest of the country about recognition of parentage, I just thought it was a disgrace. And I was told that I was brave in leading this fight. I was the dumb person who, after the lunch that we had the launch, I said, who's in charge? And of course, by asking the question, I suddenly found myself in charge. And after 9 months, there were only 2 of us, a guy named Phil and me. And on the Monday, Phil said to me, I can't do it anymore. I've got burnout. I don't blame him. It was just full on work, lobbying politicians, seemingly talking to walls and really getting nowhere. And for 3 days, I was thoroughly depressed that it was just me against the government. And by the Thursday of that week, the news broke that the government had deferred the proposal. It died and it's never revived, thankfully. We'll move on to the next slide. And my surrogacy journey, what I didn't expect back in 2012 was that I'd ever become a dad through surrogacy. So one of the ironies of my life, I suppose, is that by successfully opposing what the government had, or what the attorney at least had proposed, enabled me to become a parent later on, in the sense that if his proposal had been successful, then my now husband and I wouldn't have been able to undertake surrogacy in Queensland. It just wasn't something that was contemplated by me at all. We got together about 10 years ago. He said that he wanted to become a dad. I originally resisted that because, well, I'm older and I already had kids. And then I realised what I was doing to him was what I was looking at having done to me in the first place, which was, I don't know if I'm going to become a dad. And I thought, I can't impose that on him. We were very lucky to have a woman come forward, offer to be our surrogate, and have a friend offered to be our egg donor. But we had medical issues with both. They had to be sorted through. We had financial issues. And one of those was quite complex in that the first clinic we went to said, yes, we'll bulk bill you. And then they said, well, actually, we've had legal advice concerning surrogacy, and now we can't bulk bill you for any of the work that we do. That would have added about $10,000 to our bill, so we changed clinics. We'll go on to the next slide. And so that then meant that we were engaged in what I call the surrogacy lottery. I referred to this in the recent Senate inquiry into universal access in reproductive healthcare. But the first requirement is to get Medicare, you've got to have a clinically relevant service. And to have a clinically relevant service, you must have infertility. And the traditional definition of infertility from the World Health Organization is you have a heterosexual couple who regularly have unprotected sex and are unable to conceive after 12 months. Well, how does that fit singles or gay and lesbian couples, for example? They just don't fit that. So then we have this artificial construct that's been constructed by doctors that said, well, you're either medically infertile or socially infertile. If you're socially infertile, it's not a clinically relevant service, so we're not going to give you Medicare. If you are medically infertile, however, it is a clinically relevant service and we'll give you Medicare. The good news is that the International Committee for the Monitoring of ART, ICMART, in 2017 came up with a new version, albeit without WHO involvement. The WHO decided to exclude itself. Everyone else got involved, the International Federation of Fertility Societies, which under that is the Fertility Society of Australia and New Zealand, the FIGO, the International Federation of Gynecologists and Obstetricians, the American Society for Reproductive Medicine, and ESHRI, amongst others, all signed up to this. And in essence, anyone who needs to do ART is deemed infertile. So we now have this lottery amongst doctors. If you're a patient, do you go to Dr. A, who takes the WHO version and says, well, actually, we can't give you any treatment based on Medicare, you have to pay full freight? Or do you go to a doctor who follows the ICMART version and therefore gives you the benefits, Medicare benefits? And bear in mind, it's $5,000 for each IVF cycle, so it's that's subsidised by the Australian taxpayer. So it's a significant difference for each cycle. And then, if you're undertaking surrogacy, and of course we were struck with this, since 1991, when Medicare has covered assisted reproductive services, there's been this exclusion, and the current version is in the Health Insurance General Medical Service Table Regulations, mouthful, as you can see on the slide. And how that is perceived by lawyers is in two different ways. Some lawyers say, well, if the clinic knows or suspects that the intended parents or the patients are going to engage in surrogacy at some stage, therefore you can't ever claim the Medicare benefit. So two guys walk into the room and say they want to become parents and create embryos. Suddenly they cannot ever claim Medicare benefits. That's certainly not how I see that clause. I see it, the critical issue there is at the time of the service, there is a claim for Medicare benefits, or there's a service, the claim at the time of the service, there is in effect a surrogacy arrangement in existence. So it's a lottery for intended parents whether who are undertaking surrogacy, do they get Medicare in the first place or not? Secondly, they don't get it once the surrogacy arrangement's in place, but sometimes they may not get it at all. And on the second dot point also covers this provision, the Prohibition of Human Cloning for Reproduction Act. And section 12 of that, as made plain, is you can be jailed for up to 15 years to create a human embryo unless it's to attempt to achieve pregnancy in a particular woman. Now, there are three ways of looking at that clause. One of the national IVF clinics takes the view, because it's been told so by federal bureaucrats, that unless the surrogate is identified at the time of the creation of the embryos, then the offence is committed and it's a licence issue for the clinic. The way that I would look at that clause on its face is, well, that doesn't necessarily have to be the case. The embryo has to be created for use in a particular woman. In other words, you can't just create embryos and create a baby farm willy-nilly. It is for someone's, for the intended parents' reproductive journey. So it's going to be implanted in either one of them or someone who else identified by them, or if they donate to someone who fits that donation. But that's not actually what the section actually means. And that's because I talked to a fertility specialist who told me, well, I was there for the drafting of that clause, and the whole point of it was to ensure that the embryo is not implanted in a man, not in a man. It's all about implantation in a woman. But there you have that section that then causes grief for gay couples in particular, who haven't identified a surrogate but want to create embryos, that they may be denied treatment, because to provide them treatment, depending on the clinic, is seen as a criminal offence. Okay, we'll go on to the next slide. So we discovered that our surrogate had told us she'd had one child, that there would be no difficulty getting pregnant because, like other surrogates, she loved getting pregnant and got pregnant at the drop of a hat. And she did. But as you see on the slide, she had a miscarriage at 10 weeks. And like every other surrogate I've seen when that's happened, she blamed herself. And of course, I said to her, I'm a lawyer, I'm not a doctor, but it's not your fault. And then the doctor told us 99% of the time, the miscarriage is caused by the genetic material. A thoroughly depressing outlook when you're the intended parents, because you've got your embryo and that one didn't work, so you're going to use the next one, and you know, in effect, it's the same genetic material. So we tried again. We'll go to the next slide. Well, this time didn't work. We had an ectopic pregnancy. And that was extraordinary in the sense that in all my years of practice, I'm only aware of 2 other cases where that's happened. And I talked to lots of colleagues, no one's ever seen an ectopic pregnancy with surrogacy. And when you think about it, you wouldn't expect it to, because surrogates are fertile women. They're the ones who volunteer to be surrogates, wherever they're doing it. It was, the diagnosis was confirmed on a Monday morning. Over the weekend, we had suspicions on the Friday when we consulted with the doctor, and over the weekend, our surrogate had been looking at YouTube, and when it was confirmed on the Monday morning, there was surgery on the Monday. And I said to her, the whole point of this exercise was to give us the gift of life. I don't know whether we're going to become parents, well, so be it, but I just couldn't live with myself if any harm happened to you. The point wasn't to do harm to anyone. I love and cherish you. Anyway, she said, well, I want both my tubes out because I'm not having any more children. And what YouTube told me was that, in effect, next time round, if there's another implantation, there's a 10 times chance that there will be an ectopic pregnancy. So she had both her tubes removed. Okay, go to the next slide. And so we waited the relevant time until we could try again, and she wanted to have another go. And of course, there was no pressure from us. We just want to make sure she was okay. Yes, she said, okay, we're going to give it another go. And time went by. And at this stage, I thought to myself, this is so hard. This is much harder than most of my clients go through. And I looked out the window and I thought, why is it so hard? I do more of this than anyone else in the country, and much more than many other people. How come it's happening to me? Woe is me. And about a minute later, I looked out and thought, you idiot. You can't, no matter how much you want to, you can't control the behaviour of other drivers on the road. You can't control their stuff. You've just got to go with it. So our whole surrogacy journey took over 4 years. They're much longer than most people. And our surrogate got pregnant third time round, but as you see on the slide, our daughter almost died in childbirth. I've had 3 children, as I said. Child number 1 almost died in childbirth. There's a problem when there's 12 doctors and nurses in the room. So he survived, thankfully. Child number 2, he got induced early, so he didn't have the problem of child number 1. And child number 3, my daughter Elizabeth, she was being induced, and the drugs for the induction speed up the heart rate, heighten temperature, speed up increased blood pressure. And as I've since discovered, how doctors deal with that to minimise those side effects is to give an epidural. What we didn't know was the epidural didn't work. It wasn't in the spinal cavity. So we'd started at 9 a.m. This was at about 5 p.m. My husband says, well, nothing much is happening here. I better go home and feed the cats. And off he went to feed the cats. And he came back at 2 hours later at 7 p.m. He didn't think that anything had happened at that stage because our surrogate was asleep, and I was pretty well asleep. Oh, evidently nothing happened in the 2 hours I was away. Well, no, our daughter almost died. And in essence, she was getting cooked. Her blood pressure was up, her heart rate was up, and the midwife and I are trying to reduce the temperature of our surrogate so that she didn't cook her daughter. Looked at the monitor of our daughter and said, "Don't die me, darling." The kind of phrase that you never forget. We'll go on to the next slide. But thankfully, she didn't die, and she was born. And yet, so this photo was taken on the day of our daughter's birth. Our surrogate had gestational diabetes, and she'd been in hospital for a week. She wanted to go home, and she'd given birth at 1:15 in the morning. This was about 6 p.m. on that day, and she was told she could go home. But because she'd had gestational diabetes, the hospital wanted to keep our daughter in overnight. And even though this was the biggest maternity hospital in Queensland and had done lots of surrogacy before, this was the first time they'd struck that. And so we then faced that it went before one midwife, then number 2, then number 3, and then it went to a hospital executive, number 1, then number 2, then number 3, and then the hospital lawyer. And then just like a movie, there was that scene in the hallway between the surrogate, me, and the official from the hospital. I can't remember whether she was a midwife or an executive. And my husband, Mitch, was with our daughter in our room. And it went like this. The hospital lawyer has advised, and this was done in the hallway, that as you were the only parent looking at our surrogate, that you should not leave the hospital. What she and I instantly understood at that moment, that to me, was that as the only parent, if she was to leave, there would be no person in the hospital who could exercise parental responsibility. and that child safety would be contacted. She felt violated. She stayed in her room all night. She didn't want to talk to anyone. She was just incredibly upset. I felt like I was out of the musical Chicago, Mr. Cellophane. No, I didn't exist. I wasn't a parent. My husband wasn't a parent. The whole point of having this child was for us, for our reproductive journey. But under the law, we were not recognised as parents. Now, there's certainly been some change to it. I think family court decisions following the High Court decision in Masson, the Masson decision was only, Masson and Parsons was only a month before my daughter was born. And I thought, well, one of us is a parent under that. That's not certainly how the hospital saw it. We were just rendered irrelevant. And so since that time, since that experience that I've been through, I at every available opportunity, I think that we should have auto recognition in Australia for intended parents where there's agreement with the surrogate, with it, so we don't have to wait for a court order months later. We ultimately discharged the following day. Of course, the hospital said you will discharge you in the morning, which of course turned out to be 4 p.m. We'll go to the next slide. And of course, here are the surrogacy laws. Currently, if I go from top to bottom, there is a review being undertaken in the ACT concerning the Parentage Act. It's the oldest and creakiest of all the laws. The Northern Territories is the most recent. And right down the bottom, there has been a second review undertaken in Western Australia of its Surrogacy Act by the Ministerial Expert Panel, which reported to the government late last year, and the WA government has responded to that. So hopefully in Western Australia, there will be some opening up of surrogacy so that the amount of surrogacy there accords more with what is happening in the rest of the country. And we'll go to the next slide. And you may say, well, what did I write before she stained my shirt and after we got the order? This photo was taken at Queensland Children's Court. And if we go back 10 years, I didn't take the babies to court. It was along the lines of, well, if you don't give me the order, Your Honour, the baby gets it. You know, I thought that it might be seen as some kind of extortion of the judges. But the judges love seeing the babies turn up. And because of the experience I had in appearing in the County Court in Victoria, where photos were taken, and subsequently in the Supreme Court in New South Wales, where photos were taken, I and two colleagues were able to persuade the Law Society in Queensland to then get the Children's Court in Queensland to allow photos to be taken in the courtroom. So bland wall behind me, better than standing out on the footpath, which is what we had to do before. And I've had experience with judges in New South Wales and Victoria who've had their photos taken. Queensland judges don't want to have their photos taken with the intended parents, but so be it. So I appeared in this matter with everyone's agreement. I could appear in it in my own matter. It was the second most nervous court appearance I've ever done after the very first I did, even before I was admitted as a solicitor. And why I was so nervous, part of the reason it was my case, but it was also because of that decision in Masson in the High Court, and there had been a decision in the family court in a surrogacy arrangement that had gone wrong in North Queensland, where there was uncertainty about who the parents were, and prior to the making of a parentage order. So I had written submissions that went for about 30 odd pages, about 20 odd pages devoted to that. The judge agreed with me on the point, but didn't get a ruling. I got a ruling later that year saying that the family court decision in North Queensland was wrong, which was very helpful. So I'll just say this: test cases are really interesting, except that when they're your own. And after the court appearance, we walked up to the Brisbane Mall. We had Queen Street Mall. We had a drink each, the three of us, not Elizabeth, had surrogate. And then the two of us decided, Mitch and I decided to go off to get Yumcha in Fortitude Valley. So we walked to the car. By this stage, Elizabeth is screaming. And we think, okay, well, when we're in the car, everything will be calmed down. She won't any longer be like an air raid siren. None of that worked. By the time we drove to the restaurant, that we wanted to go to. We discovered that it was for lease. It had closed. So the next thing you know, I'm in an underground car park of a shopping centre in a semi-gloom. He wanders off to go to the toilet. I'm feeding her. I've taken my coat off by this stage, and I discovered the joys of parenting, that not only was she hungry, but of course, all the other reaction happened at the same time. And I then had to change her nappy, and he comes back. He has to get rid of the nappy. She's calm by this stage, and we say, well, why don't we go to the cafe down the road from our place? We end up there and order lunch. And by this stage, of course, I've got a lunch in front of me. I'm sitting in the sunshine, and I discover with that lovely white shirt that, in fact, I have a lurid green stain going down one arm, courtesy of my daughter, from what had happened in the car park change. What did I do? I ate. Okay, did you eat? This is what you do as a parent. Okay, go to the next slide. And a few months later, I was contacted by a journalist at The Australian, and he wanted to talk about what's new and interesting in the world of surrogacy. I talked about my concern about people going to China. And then I said, by way of disclosure, my husband and I have had a daughter via surrogacy in Queensland recently, and we had to get a special ruling in our own case because of issues about who was a parent. He suddenly saw that as newsworthy. I didn't see it as newsworthy. I just thought, oh, that's part of our life. I didn't see it that way. And he said, what? Australia's leading surrogacy lawyer has to have a special ruling in his own case. That's newsworthy. And I said, okay, well, you're the journalist. I'm only a lawyer. And as a result, this photo was taken by the photographer from The Australian at our home, and the story ran in The Australian just before Christmas 2019. In those days, Facebook had a feature, which this might be you, with photographs. So they've got rid of it now. And I clicked on that, and to my horror, under the tag that said no bullying, the convener of the Australian Christian Lobby put a post on her site with one magic wave of a gavel. This little girl has been forever denied her mother. And then the pylon started from everyone else, criticising us. Well, a gay couple were not naturally parents, and then saying things like, well, no matter how many times they try, they can't have a child. Clearly the intellect of the group, and likening us to paedophiles. It was really, really grubby stuff, really grubby. The advice I got from two people was along these lines. A judge told me, don't let the haters win. And a colleague told me, and excuse my language, 2 words of advice. He said, fuck them. But it really left a bad taste in the mouth. It was only when we marched in Mardi Gras in February this year, when we had 200,000 or 300,000 people cheer us on for being parents, that there was healing as a result of that awful, really awful experience. We'll go on to the next slide. And I just want to highlight this photo. This photo was taken of Elizabeth when she was 18 months old. And as you'd see, she had the particular knack of putting the yogurt bucket, empty yogurt bucket, over her head. You may wonder why I've got this photo of her at 18 months, because she was in a childcare centre of 165 families, really big centre in the centre of Brisbane. And yet, of those families, there was only one family that had 2 dads. That was us. There wasn't any family that was obvious that had 2 mums. There are a few single parent families, but most were heterosexual couples. She realised at the age of 18 months, so of that age, as you see in the photo, that she was different to every other child there, because she was the only child who had 2 dads as parents. And she realised at that stage that we had to have a name, and she called my husband Dad and called me Daddy. And those have been the names that we have been known by ever since. So this, a lot of this debate about when children should know about where they've come from and when children will work out where they've come from, this is just an illustration of how early it can be at 18 months. Okay, we'll go to the next slide. I've done that one already, sorry. I've covered it twice. if you just go to the next one about, is that the next one? So WA, and you can see, I was critical of WA laws. WA laws exclude same-sex or male couples and single men. Who knows how non-binary, transgender, or intersex intended parents are covered? But half the market is missing in WA, and WA has a very structured form of surrogacy, that probably the most structured in the world, including that any donor of genetic material must be known and must be a party to the surrogacy arrangement, and that there's pre-approval required from the regulator, the Reproductive Technology Council, and there must be a minimum 3-month cooling off period before that's obtained, and on it goes. There must be a plan entered into at the time that the court makes the order as to what involvement the surrogate's going to have. And so what do you see? Every year there's been one birth, according to the Reproductive Technology Council, that's occurred locally. I'm told by a WA colleague that there have been 3 births in 2023, so that's really out of the norm. And the Department of Home Affairs keeps statistics of children who are born overseas via surrogacy and apply for Australian citizenship by descent. And what I've done with those statistics is divide them by 10, because on a per capita basis, WA has 10% of the Australian population, and look at the disparity that in 2020, for example, for 1 child born in Western Australia, 27 are born overseas. We go on to the next slide. And in 2021, this just gives you an illustration. In rough terms, for every child born in Australia by surrogacy, 4 are born overseas. And I base those statistics on figures produced by the Australian-New Zealand Assisted Reproductive Database from the University of New South Wales, which talks about children born via gestational surrogacy through IVF clinics in Australia and New Zealand. And then the New Zealanders have paid for New Zealand figures, and then I've just done the maths on that, and then compared that with the number of children born by surrogacy overseas who obtain Australian citizenship. And it's rather depressing that more Australian children are born via surrogacy in the US than in Australia. And number 2 there, of course, Ukraine now will be drastically down. In about next year, Georgia will be drastically down, because from 1 January 2024, surrogacy isn't available, won't be available to international parents in Georgia. And Thailand is interesting, because even though Baby Gammy and the Thai baby farm in 2014 prompted Thailand to greatly restrict availability for surrogacy, nevertheless, we've seen Australians continue to access surrogacy there. We'll go on to the next, and sorry, just go back to that last one. And so we see here that this figure of 186 at the bottom of the 223, so about 15% of overseas births don't occur in the prime countries, prime surrogacy destinations. They occur all over the place. And what I see in practice is that these are intended parents who have migrated from those countries and go back there. And we're talking about places like Ghana, Nigeria, Bangladesh, Sri Lanka, and Iran, for example. Okay. And so what we are seeing, I don't know whether I've got that right. Oh, through Thailand. These are the Thai figures. So you can see, following the 2014 Baby Gammy case, we had this overhang in 2015 and 16, and then the numbers just dropped. But here we've seen a continuation of numbers occur, and you'd say, well, okay, we've had a number of Thai citizens live in Australia, which is one of the prerequisites. Surely that might apply, not at those numbers. And what I've heard through clients and international contacts is that this is reliant on loose borders between Thailand, Laos, Cambodia, and also Malaysia and China, amongst others. Okay. And there's the comparison. This figure, we don't have a precise, these figures 61 and 76 in 2019 and 2020. They're estimates by me on a per capita basis between Australia and New Zealand. The New Zealand figures aren't any more recent than 2018. But you can see how it compares, the US compared to Australia. These Australian children being born, which is depressing. So our journey, we're one in the five who are born in Australia, as our daughter being born in Australia as opposed to overseas. Okay, and this gives you a comparison, and you'll see that over time, gradually, there has been an increase in the amount of domestic surrogacy occurring in Australia and New Zealand. The New Zealand figures are even more suspect than the Australian ones, because I'm told that there's a decent amount of traditional surrogacy occurring in New Zealand, and typically they don't occur through clinics. So there aren't precise numbers on the number of traditional surrogacy births in New Zealand. And we'll go to the next slide. And the key here is 2011, 2012. And if you look back at 2010, the comparison between domestic and overseas, they're about the same. What happened? Well, Linda Burney stood up in the New South Wales Parliament and said, I want to amend, this is in the third reading stage, so right at the end, I want to amend the surrogacy bill to criminalise New South Wales residents or those domiciled in New South Wales from undertaking commercial surrogacy overseas. This was something that had not been part of the Upper House inquiry, not been part of the government's response to that inquiry, and not part of any of the community consultations. There was, to put it bluntly, a media firestorm, media and community firestorm. The reaction to that was that many people who didn't know that they could do surrogacy suddenly thought, oh, well, I can do it, we can do it. And as well, there was organisation of surrogacy events. Surrogacy Australia was formed, and seminars continued to be held. And even VADA, as of April 2011, a month after the New South Wales Act commenced, brought out a doctor from India to talk about cross-border reproductive healthcare, namely how to bring your child home from India. And so we see this enormous number go from 10 by 2012 to 266. And as you can see, it's largely remained north of 200 ever since. And if we go to the next slide, you will see that most of that 266, contrary to what Linda Burney wanted, which was to prevent people, in effect, going to the developing country surrogacy hub at the time of India, going to India, 227 of them were born in India. And you'd have to say, if we're talking about a third of those, about 70 of those were from New South Wales, because New South Wales has per capita about a third of the Australian population. So really an own goal. It just didn't work. New Zealand researchers have described these extraterritorial surrogacy laws, which we have in Queensland, the ACT, and New South Wales, as a failed experiment. And I think these numbers really demonstrate that. And we see the numbers drop down to zero. That's not because of anything we've done. That's because India has slowly tightened surrogacy. It did originally concerning Australians in 2012. Then 2014, in essence, following news of a surrogacy journey in India by Australians, decided, no, we don't want Australians undertaking surrogacy here at all. And then there were further restrictions in 2016. And finally, about a year or so ago, there were laws there to prevent anything but altruistic surrogacy and not for foreigners. So the numbers have dropped, as I said, to zero. Go to the next slide. And there's my book, for what it's worth. And we'll go on to the next slide. The eyes have it, excuse my pun. That's my daughter, and that was taken about a month or so ago at a conference in North America.